for the meeting, but Brenda, would you like to open since you were the last chair?
I can.
Thank you.
I'd like to call the meeting to order.
And the first item on the agenda is the election of officers. Are there any nominations?
I'll nominate Brenda as chair.
I'll second. You're good to go.
All right, I'm good to go.
Are there any further nominations? Seeing none, I'll entertain a motion
A motion to vote?
to elect Brenda as chair.
Yeah.
Okay. Seconded?
Yep.
Thank you. All those in favor? I give you the floor, Madam Chair.
It's a tough race, but you made it.
It is, I know.
And then if
So-
you want to elect a vice chair, you can, otherwise you would go on to the public hearing.
Okay. Would it be suggested we do a vice at this point?
You could.
Why not?
Okay. So a nomination for vice chair?
Nomination for vice?
I nominate Mike.
I second.
Sneaky.
Any further nominations? I'll entertain a motion.
I'll make a motion that Mike becomes vice chair of this committee.
Is there a second?
I second.
All those in favor?
Aye.
Thank you. The next thing on the agenda is a public hearing.
The remote
Remote.
participation policy.
Yes. And for that, you probably haven't done a lot of public hearings.
No.
You'll need to open the public hearing, see if the public has any comments.
Okay.
And then close the public hearing.
Okay. At this point, we'd like to open the public hearing for the remote participation policy. If anyone would like to speak about that. Okay. I guess we'll close then.
I'll make a motion we adopt the remote participation policy. Is that it? No, remote meeting participation policy.
Yes.
Like that.
I'll second that.
All those in favor?
All in favor?
Yep. Yes.
The next item on the agenda is the training
The
workshop.
training workshop.
Okay. I have a memorandum that I'm going to work from, so I'll pass copies out.
Sue, shall we sign this document now?
Yes, please. As your-
Oh, yes. good.
Brenda, do you prefer Miss, Mrs., Ms.?
Ms. is fine.
Thank you.
Thank you.
Thank you.
Well, good evening. My name is Jim Katsafikis. I'm with the law firm Perkins Thompson in Portland, and I'm here tonight as conflict counsel representing the Board of Appeals and the Board of Assessment Review acting on this appeal. I think I heard beforehand that it may have been as long back as 2012 when this board last met. Maybe a little more recently, but it's been a little while. And usually when this board meets, I assume it's for valuation questions. People are upset about their property taxes and they're coming in for a general abatement because they think they're overvalued, or maybe they might even think that there's been discrimination in taxation, and they want to try to reduce their valuation and reduce their tax burden. That's what typically boards of assessment review hear all the time. But there's another type of appeal that state law allows for, and that's for hardship or poverty abatements. When you're dealing with property valuation, the question is, what is the property worth? It really doesn't matter who the taxpayer is or what the taxpayer's situation is usually. It's usually your focus is the property and what's its fair market value, so what should it be assessed for? With a poverty or a hardship abatement, we used to call them poverty or infirmity abatements, but the legislature changed that a few years back. With these hardship or poverty abatements, the question is the taxpayer situation. Is the taxpayer unable to contribute to the public charges because of poverty, because of circumstances, economic circumstances and hardship? So it's focused on the person and the person's finances, not on the property. So it's a really different focus from what you usually do. There is a statute. It's section Title 36, Section 841, Subsection 2, which I've reproduced here as part of this memorandum, just so you have all the statutory criteria in front of you, because this is one of those things where you are going to be hearing facts in a hearing. You will be receiving facts, and you'll be applying the law to those facts. So it's probably helpful to see some of the law and some of the requirements. But without making you, go through that particularly, just it really is a question of whether the person is able to pay taxes because of reasonable expenses and income issues. So typically what's done is municipalities have a form. It's much like a general assistance application form. And you obtain information from the applicant on that form about their income, which would be any sources of income and any available assets that they might have. And then you look and see what are their reasonable necessities for expenses. Not suggesting that a vacation trip might be on there, but that sort of thing, it's not necessary, it's not what you'd be looking at as the sorts of reasonable expenses. You'd be looking at rent, you'd be looking at heat, you'd be looking at utilities, you'd be looking at water bill, the standard groceries, the standard ordinary reasonable expenses and necessities of life that people have to spend, and looking to see whether, it's between income and necessities, do they not have an ability to pay their property taxes, and so therefore they're getting a poverty abatement. So it's not just for any property, it's for the taxpayer's principal residence. So vacation homes don't count, second homes or whatever wouldn't count. When you're looking at the property too, you're looking at the dwelling, the house, and the reasonable amount of land that would support it under the zoning ordinance. So if they've got 50 acres and you have a 1 acre minimum, potentially that person could be selling off some of the excess acreage in order to be able to pay some of the taxes. But what you're looking at is the primary residence, you're looking at the home, the land that supports it, whatever is reasonable under the zoning ordinance to go along with that. The town has to, when people request or are interested in this, the town has to make information available as to how they do this and show them what the process is. They're supposed to help the people who are applying to make that application for an abatement. And the abatement first is heard by the select board. So the select board would hear it, and then appeals can be taken to this board. That's how something like that would find its way to you. Normally, for valuation appeals, they go to the assessor first and then come here. So it's a little bit different. It's the select board that gets to hear these in the first place. What's also a little unusual is boards are supposed to meet in public. And there's a preference that you do meet in public. You only go into executive session to meet with your attorney, or it's unusual circumstances. But to protect the privacy of the persons and the data involved, this will be held, any poverty abatement application is held in executive session. So you'd move from the public session, enter executive session for this purpose, to hear the abatement appeal. And you would conduct the hearing in executive session. Normally you don't do that, but you would be conducting the hearing in executive session. Any information that you receive, any written information that you receive, would be confidential. So it's protected. Normally records received from the transaction of public business are public records, and they're available under the Freedom of Access Act. But no, these would be confidential as an exception to that Freedom of Access Act, and we will, we'll keep the discussion confidential. when you have finished deliberation and you're ready to make a decision, decisions can't be made in executive session, and so you would move to go back into public session. And when you're back in public session, then there would be a motion as to how to deal with that application. We won't give an applicant's name. Either it would be to grant or deny or partially grant or whatever the appeal, or it would have a case number. And we'll talk about that, but are case numbers used?
Well, this would be case number 1.
Sounds like case 2022-1. Okay, but that's one way you could do that to protect the privacy of the individual and the confidentiality of the data. There are further appeal rights from here, but I think that's the most important, procedurally, just to understand. We'll all be dealing with this in executive session until it's time for a vote, and then that will be in public session. I have draft motions here on page 3 to help out, so we can work through that when it's time. The applicant has the burden of proof of entitlement to a poverty abatement. And so I know that this board does have rules of procedure. And those rules of procedure, though, are generally designed with the standard abatement, where the assessor comes up and summarizes the case, and this will be handled a little differently. It will be the applicant putting on a case, and the board can ask questions. The assessor can ask, the town can ask questions, the town's attorney. And the town's attorney is here tonight for that purpose, and when we get to that later. And then the town gets to put on its case, the board asks questions, and then the applicant's attorney can ask questions. So that's how the hearing would be held. It's not an open public hearing for everybody to come in. It's only those people with an interest in this particular matter. It's all in executive session, all confidential. That questioning will go on. And once the questions have been asked and everyone's had a fair chance to present their case, and then to rebut each other's evidence, will allow for rebuttal. Then it's time to close the public hearing, or close the hearing, I should say. There won't be any public. To close the hearing. And at that point, then the counsel for the applicant and for the town will be here if you have questions, but they don't have a right to speak. The hearing is when people have a right to speak. Once the hearing's concluded, they can speak if requested by the board. That's going to be up to you. But that's then the time for you to deliberate, just like on your other applications. You deliberate in that stage. We're going to deliberate, you're going to deliberate in executive session, and then when you feel that you're ready to reach a conclusion, and it may not be in the same meeting. You may decide we want to mull this over, or you may decide you want some additional information, or you may decide that you want to maybe do a straw poll and see it in writing, see a draft decision in writing, because you will want to issue a decision in writing at the end. That's required by the Freedom of Access Act and required here under the statute. There'll have to be a written decision with findings and conclusions that people can then proceed as they will with. And that decision would be rendered, again, it would be confidential, but that would something that the town would protect. So that's the process. It can be appealed to the Superior Court within 60 days of the decision, but that's again for the parties to decide. This is what we call a de novo review. When a Board of Appeals, for example, holds an appeal hearing, there are two kinds of appeal hearings. One of them is strictly appellate, where you look at the record of what happened below and you decide, was it correct as a matter of law? Is it supported by facts? Was there any abuse of discretion? That's it. You're not rehearing testimony, you're hearing argument, and you just decide the case, was it right or wrong based upon what was presented below. That's not what you're going to do. Tonight is going to be, it's going to be a de novo hearing, meaning you hear it anew, you hear it afresh. You're taking all the testimony and you are making the decision over again, as though you were in the place of the select board. So you will hear it, and you will get to decide credibility, and you will get to weigh the evidence, and you will make the decision on a de novo basis as to whether they've met the test. And the test, again, really is, the state Supreme Court announced or described it as whether the applicant's reasonable expenses for necessities exceed their income and available assets. That's from the Macaro versus Town of Wyndham case back in 1983. This is on page 3 of your outline. But that's the test. That's the primary thing. A poverty abatement, because it's looking at an individual, a person, is only available for natural persons. Corporations can't come in for a poverty abatement, but the poverty abatement is only for the primary residence, as we talked about. The fact that a person may own the home isn't used to deny relief. It doesn't disqualify them. The reason for this abatement is to try to keep people in their homes. That's what the state Supreme Court has indicated to us in the Macaro decision. So the idea isn't to require people to sell off their homes. When you think about that, it could wind up with them coming in for the general assistance application and having problems finding housing. It's to encourage them to keep their homes and yet give them relief where it's appropriate from property taxes if they're otherwise unable to pay. The person has to have standing, the homeowner, or has standing because it's their house. But there have been some interesting cases where people claim they have a bond for deed, and it's an unusual way of financing property that's kind of unique. But if it's we're not worried about an installment sales contract here. I believe this property for something like this evening's case would be subject to a mortgage conventionally, and the applicant would have standing as an assessed taxpayer. There's some issues here that are raised. You've heard of having a life tenancy, where you can stay in the house for the remainder of your natural life, but the house will revert to other people, and they own the rest of the remaining interest in it. In that case, the life tenant's responsible for taxes, property taxes under Maine law, so therefore can bring the abatement application. What time frame do we look at? Well, we're looking at the economic situation of the applicant at the time of the application and throughout the whole tax year. So it isn't just one discrete period of time. You're looking throughout the time period from when the tax was assessed, and from that tax year up to the point when the application is filed. And so that's what we look at when you're measuring assets and necessities. There are particular federal assistance benefits where by law they aren't counted as income, and that would be SNAP, food stamps as it's sometimes known, and also LIHEAP, the type of federal fuel assistance program payments. Those are not considered income for purposes of poverty abatements. We look at these on a year-by-year basis, and the fact that a person may have received a poverty abatement in a prior year does not mean that they're going to be entitled automatically the next year. Each year is its own case, and the showing has to be made by the applicant in each year. That's, for property tax exemptions, it's a little different. If someone comes in as a nonprofit and shows that they're contributing to the community and they fit one of the pigeonholes for nonprofit corporations under Maine, then maybe they get an exemption, and once they qualify, they continue to qualify unless something's shown where they don't anymore. Here, it's each year is a separate case. And if they're receiving monies, some payment under the Maine Residence Property Tax Program, you may, it's not required, but you may deduct that amount from the amount of property taxes that are owed in order to reduce the amount of abatements. So that's something that's available under the statute. So those are the basic ground rules. There will be questions anytime these are required. We're trying to apply this and see how it all works. But those are the basics developed from statute, developed from case law. Some of the materials that Maine Municipal Association has provided, I've tried to summarize in one place for you, so that at least it's a starting place, and we'll go through that as we proceed. So that would be Poverty and Hardship Abatements 101. And with that, it would probably be appropriate to take up the consideration of poverty abatement denial appeal and to move for there to be a motion for executive session. And if you want, I'll give you the motion. You can say so moved, and you all can approve. It would be a motion for the board to consider poverty abatement denial appeal in executive session pursuant to 1 MRSA Section 405, Subsection 6F, and 36 MRSA Section 841, Sub 2, Sub E.
So moved.
Is there a second?
Second.
Okay, all in favor? All right. We are now entering the executive session zone. Would there be a motion to continue this hearing to Thursday, June 9 at 7 p.m.?
At 7 p.m.? So moved?
And when that meeting is held, just to add to the motion, is that going to be hybrid? Is that going to be by Zoom, or is that going to be in person?
Hybrid.
Hybrid? Okay. All right, so
Sounds
the
good.
motion is to continue this meeting to Thursday, June 9, 7 p.m. to be held as a hybrid meeting. There's been a motion made. Is there a second? And all in favor? And is there anything else on your agenda for this evening?
Well, just about the agenda on the 9th is to approve what we did tonight.
What it will be to complete what was done tonight. And so we'll move to go into executive session to complete deliberation on the appeal.
Yeah.
And then once that deliberation is complete, then you'd go into public session, adopt it, make your decision, your actual decision, adopt the findings, and then we're done.
So is there a motion to adjourn?
Motion to adjourn?
I'll move that.
Adjourn.